Welcome to the Law Spot Podcast with your host, Melissa Gray. Join her as she highlights legal professionals and trending legal issues facing entrepreneurs and small business owners. Ready to dive into life and law? You're in the right spot.
Welcome to the Law Spot. I'm so excited about today's guest, Gabriela Smith, who is a fellow lawyer and friend. Originally from Argentina, she routinely advises clients on international contracts and regulatory matters and is the counsel of choice for Latin American companies doing business in the U.S. So welcome, Gabby.
Thank you.
Gabby, will you just share a little bit about your practice and how you got started in this very particular niche and explain a little bit about your firm?
Sure. So I've been practicing for 14 years now. I started at a medium to large law firm in Pennsylvania as a commercial litigator. And then I decided that I wanted to become a transactional lawyer. So when my husband and I moved to Texas, I transitioned to a transactional practice, primarily focusing on international businesses coming to the U.S. and selling their services here. I found that niche by researching, what would be a good type of client for me to work with in a very natural and cultural way. With having kind of an American culture and a Latin American culture, it's really easy for me to relate to my clients, but I can also help them navigate the entire U.S. side of the business. So I've been at my firm for almost 10 years, and I basically represent companies that provide services, and I represent them in the entire business cycle from company formation to contracts to issues that arise, compliance. And then I love to work on the project of sale. Once the client decided that they got big enough that they want to sell, I help them with the sale of their business. And I would say that probably 90% of my clients are inbound businesses from Latin America or other parts of the world, but primarily Latin America that provide services to U.S. companies.
Do you find that companies in Latin America are really hesitant to contact a lawyer from the beginning, and why do you think that is, and what do you share with them to get them more comfortable with like the whole process of engaging with a U.S. lawyer?
Yeah, so there are really two types. I can probably classify these companies in two categories. One category is a do-it-yourself, and they jump in and they do it themselves kind of by Googling, trying to find out what to do. And then they call me when they have a problem or they get stuck or they get screwed. That's like, unfortunately, part of my language. So that's one. And then the other type, I would say, is a very cautious, aware that they are in a completely different environment, in a different country, in a different type of legal system. Latin America is primarily a statutory legal environment where everything is written by statute. In the U.S., we have a common law system. So that's one of the main differences. So I would say that the better option is to always contact a lawyer before you jump on a transaction. I've seen a number of deals that were either made online, with forms found online, with services that are purporting to provide a legal service that really isn't. Yeah. So my option is always to call us, the lawyer, whoever they choose, before they get into a deal, because if you call us after you get into the deal, there's only so much that we can do. We're bound by the deal that you made without asking. So the better option is always to call first.
So, and I want to get into some of those stories where they got screwed and then called you, and then you tried to sort of pick up the pieces. But you recently touched on like the myths about doing business in the U.S. So I don't want to skip over those because I think it can add a lot of value to people that are in Latin America or another country about the differences that stem from the legal system or culture, but are really contributing to their hesitation. So can you go through those things and maybe debunk some of those for us?
Sure. I actually got published in Forbes Argentina and Forbes in Uruguay, talking about 4 very strong myths that exist, I would say, all over Latin America about doing business in the U.S. So the first one is that it is very complex and very difficult to either form a company or run a business in the U.S. And that myth is really founded on the notion that in Latin America today, in 2023, it is still very hard, by and large. I don't want to, it's not a blanket issue, but it's a majority of the countries make it very hard, difficult, and long to create a company. And then every step of the way, a lot of the things that we do in a private session in the US, like a company agreement or corporation bylaws, in Latin America, those have to be registered documents and stamped in, with different peoples and notaries and lawyers and semi-quasi lawyers, which is also a type of lawyer that exists there. So the truth in the US is we don't have any of that here. Generally, forming a company is very simple and running the company is very simple. In Latin America, for example, for people to maintain a company open has to, in certain cases, have a certain revenue or do certain filings or certain reports to the government. By and large, that doesn't happen in the US. For example, the only filing other than paying federal taxes, right? But the only filing that you have to do in a Texas LLC is your franchise tax report, which is a one-time or once-a-year report where you just have to tell the state how much money your business made. And then if you meet certain thresholds, you have to pay taxes. That's the only situation where you have to report to the state. It happens once a year. And if you don't report, then the state can actually cause the suspension of your business. But that's really the only type. It's not an ongoing, quarterly report or anything like that. The second myth is also one that I've actually seen happen to a client that was ready to sell the business. Is the myth is that you have to have an American shareholder or an American LLC owner, right? One of the members has to be an American citizen or resident, or else you can't form the company. That the issue of having at least one shareholder who is a owner in a business is very true in other countries. Not in the US. You don't have to have a US citizen or resident as one of your shareholders. You can be 100% foreign owned and you don't have to have that person. So what happened to that client is that he was selling a business, and I saw in the papers that there was a 1% ownership in a third party that he wasn't even in connection with anymore. And unfortunately, when we went to sell the company, we had to pay that person their share of the sale. Because that client had, mistakenly believed, or somebody made him believe that he needed a local owner. So, okay. The third myth, and this has come up in my practice many times, is that if you are not a citizen or resident, you can't sign a contract, an American business contract. And that is not true. There is no requirement of having citizenship. The only requirement to sign a contract is that you have capacity, legal capacity. That's a matter of local law, of state law, which is you have a mental capacity and the age to sign a contract. And the age, it depends on the state, but I think it's 18 or 21 years old, depending on the state. And capacity means that you're able to make decisions, that you're not under judge's order to have somebody else make decisions for you or anything like that. So no, you don't have to be an American to be able to sign the contract or bind your company to an agreement. And lastly, the one that affects, I would say, equally American small businesses and foreign businesses is that I shouldn't negotiate the contract because I don't want to make the other person upset. I don't want to create any friction. Maybe, I don't want to lose the client. I don't want to offend somebody. But the truth is that in America, we negotiate contracts all the time. Even if you're negotiating with your family, you should have a good contract. Nobody will be upset if you want to change something that is more beneficial to you, or that maybe makes the contract more even, or things of that sort. So those are the 4 myths of, doing business in the U.S. Yeah.
Awesome. Well, and that last one I think is when we were talking before, you said it's sort of a cultural thing too. They are in Latin America, they're less adversarial than we are in the U.S., or what they perceive to be adversarial and pushing back. So I'm sure you have experienced that in your practice, where they failed to put a document in place, or they accepted terms that were less favorable to them. And when we were talking about this podcast, I thought we could do a little story time on a couple of those that you've encountered, and then maybe, rewind and say, okay, this would have been better for them if they had followed this instead. So friends and family, a lot of times, don't want to put in those things. And so share with us, a few of those stories so we can highlight how that happens. It happens so easily, but also why it's so important to put those boundaries in place up front.
Right. So, it really starts with the fact that today is very easy to go and open an LLC online without actually talking to a lawyer who would tell you what your options are. So we see people come and tell us, hey, I have this LLC. I went on this website, this other website. I paid $50 and then I got these papers, right? And I'm doing business with my friend, my partner, my girlfriend, my wife, my ex-wife, my cousin, whoever. And now things are happening. So one of the ones that we've worked recently is 2 buddies, best friends. One of them more business savvy than the other, who took the time to get a lawyer and offered the other party a very small percentage of the company, and to grow one of the branches that the company opened. And in that situation, the guy that was growing that branch was very hardworking, very trusting, and signed the papers and worked. And fast forward to the recent times, the buddy who created the company, when bothered to talk to the lawyer, wants to sell the company, and issues come up when the person who actually built the company and this particular branch wants to protect or understand his rights. Well, his rights are very limited because back in the day, 10 years ago, he signed certain things that were allowing the business savvy person really control everything that happened in the company, the sale process, and things of that sort. So we are at this point where not only this is at really 3 hats. The 2 friends are business owners of the same company. One of them is an employee, and the 3rd layer, they're friends. We go to each other's weddings, we go on vacations together, but then the truth is, as much as you could love your friend, your family members, unfortunately, sometimes humanity shows the greedy side. And when it's time to talk about money, people are not as loving as they were when they were having drinks, in Cancun. So we have a threefold relationship that's very difficult to navigate between one friend who's still very loyal to this other friend and doesn't want to say too much. The other friend who's really not caring. You can see that. And then you have one friend, one of the people is an employee, afraid to say his capacity as an employee. He doesn't want to get fired. He's trying to figure out, what are my rights as an employee? Am I going to get fired if I claim that I won a piece of the sale? So it's that fear. And then the fear of what's going to happen to my sweat equity. Yeah. What's happening? Do I have access to the records as an owner? Can I see the business records? Can I see the conversations with the potential buyer of the company? So it's a very, very complex, as little as it sounds, two guys doing business. I mean, it sounds very basic, very simple, but it really isn't. Right. And then for us lawyers to sort it out, I mean, you have to read the documents that were signed, and you have to compare that against the law and understand is anything out of bound? Can we claim that this agreement is not valid because the law doesn't allow it? And then there's the emotional side of the entire situation. Now, how could that have been resolved is spend the money. I mean, spend a little bit more money in the front of the deal and get the lawyer, get a good lawyer, get them to tell you your rights. Because, lawyers could also be pulling documents offline. I mean, understand the document, understand the law. What are your rights? What protections should you have to be able to enter into business with anybody?
So let's go through those controlling documents. LLC, corporation, what are the versions of those documents, and what are the provisions that you would say, let's say that they don't have a lot of money. At a minimum, what should they be honing in on that is really going to impact their ability to, go into the future should the company grow, and where do they want to focus when they're presented with this thing that's overwhelming to them?
Right. So let's think about for the LLC first. The first thing you want to make sure is that whatever percentage you agreed to have, you actually have in writing that you own that percentage. Or if you agreed to have sweat equity where you would work and after a certain time you would earn that percentage, then make sure it's in writing. I mean, a handshake technically a handshake would be valid, but then you would have to go to court to prove, and you need witnesses to show that, yes, I heard him say that he would have X, Y, and Z. So it's easier to prove that you own a piece of a company if it's actually written and if it's written well. So that's one. And make sure that whatever sweat equity, whatever percentage you agreed to have is actually in writing. Okay. Other things. If you are especially if you're going to be a minority owner, that means somebody who owns a small portion such that you don't have the voting rights on major decisions. If you have a minority ownership, if your body says, I'll put $100K and then you run the business for 20%, and to make major decisions, you need to have a 50%. As a 20% owner, you will never be able to vote on anything. And so understand, if you are a minority owner, what are the rights that you don't have? For example, right to bring other partners, the right to sell the business, the right to sell the assets of the business, the right to be diluted. So if your majority partner wants to bring more people and then they want to dilute your 20%, there's also some non-competition issues. See what you're signing. I mean, there's so many things. There's an entire code in Texas and a similar code in every other state that talks about these issues. So make sure you understand what you're getting into.
So let's say you're fine being a minority owner and you know that you're never going to have decision-making power, but this person ends up wanting to go through with a sale. What provisions do you want to at least protect the valuation component and make sure that you are getting what you're owed for that particular percentage?
Right. So you want to make sure that you have access to the documents of the company. That's generally granted to you by law. And you want to make sure that the company agreement that you signed doesn't restrict that in any way, such that the person would have grounds under the agreement to fight you over it. Even if the law gives you the power, if there's anything in writing that restricts that power and that person wants to go with a restricted version of that, I mean, you just have to always have, and this is where the negotiation point that we talked earlier comes in, is you always want to make sure that you have the necessary power. So access documents, in any, minority owners should have the power to approve the sale of equity or the sale of the assets of the company. And you should make sure that you have some kind of power to get what you deserve. And that those are just two of many that we could talk. There's also rights. I mean, and it depends on, again, some of this turns into your level of knowledge on the management of an LLC. There are other things that can happen that can help you or hurt you. For example, you should see if your LLC agreement has a clause permitting the majority member to drag you into a sale that you don't agree. There's drag along and some other rights called tag along. Some are more friendly than others, but the majority owners, if they drafted their company agreement in their favor, they will have rights to dilute you, force you to sell, or allow the company to issue more membership interest, diluting yours. So in that case, for example, to prevent dilution, you want to make sure that you have a preemptive right to buy a percentage that is proportionate to what you already own, so you're not diluted. So there's so many options, some of which don't really come up in the small business, but a small business can also grow very fast. In this viral social media world, you can have people who become, big businesses overnight, bringing money overnight. And there was actually in the news about a nurse that, I don't know if you saw it, but she published something on TikTok and her business became a boom overnight.
Yeah.
So, yeah.
Well, and I think getting back to just that upfront investment, that this is a hot button issue. It's like the same thing in my practice where people don't think that filing a federal registration for a trademark is necessarily worth the money because they don't see the immediate return. But when you're in a situation where you're just starting and you're deciding how much to put aside for legal fees, right, what conversation do you have with the client about, like, what is a reasonable amount to invest in these sorts of things on the front end for, like, your protection long term? Because I've heard you had this. I heard you had this discussion with a client, and I thought it was really well done. So I think that would be a lot of value.
Right. So, I mean, I think you should, if you're starting a business that will be your income, right? If you're starting a business that you're betting on, it's not a passive business. This is something that you are putting your time, your sweat equity, Monday through Monday, 24/7, or even less, right? I'm going to the extreme, but if you're going to dedicate your life to this business, you should be willing. I think for $1,500, $2,000, you can get a lawyer to review the company documents and to explain to you what is in them and what is not in them. So you can make an educated decision as to what you should argue and shouldn't argue. In the example that I'm mentioning with a person who did not argue, who did not read the papers and who signed, I would have just a few tweaks in the existing contract would have left this person in a much better place. I would have the person also, we talked about wearing the hat of a friend, the employee, the business partner. They don't have a written employment agreement. So the person becomes an at-will employee almost automatically by law. So what do you do? What do you do as an employee? What do you do as a partner? And then your friendship, I don't know if you can save it. So these are the things that you want to pay attention to. So yeah, I would think we're not talking about $10,000. I think, a good lawyer should be able to review the contract and help you, at least give you tips, a discussion point with your friend, your partner, to be able to understand. Or if you're okay with risk, at least understand what you're risking. Because you're talking sometimes pay the lawyer now to do a good job with your, starting your business, or really pay the lawyer later when you're fighting over potentially millions of dollars. So I'd rather pay, $1,500 now, $2,000, whatever it is, and not pay $50 later, hiring a litigator who will have to spend hours and hours building a case with a case that has a lifespan of however many years you were in that business.
Right. So you mentioned non-competes in the context of these partnership agreements, and I think that's really important. The FTC has already said there's going to be some shift in that arena, but let's say you're subject to an agreement today that has a non-compete in it. Why is that so important to pay attention to, and what are the key components of that in relation to these agreements and where that can leave you in the event you're a minority owner?
Right. Okay. So non-competes, for everybody listening, they can be in different types of documents. You can have a non-compete in a employment agreement. You can also have a non-compete in your partnership agreement, your LLC agreement, some other corporate documents. So I know there's a lot of information out there on employment agreement. They're very regulated when they're valid and all of that, because essentially the government doesn't want homeless people because they signed a commercial agreement, right? So I'm not going to touch I'm not going to discuss the non-competes in the employment agreement, but the non-competes can take different shapes and forms in company agreements, particularly with the LLCs, right? And so what could you see in LLC agreements that you need to understand or raise your hand or flag it? You can see discussions about fiduciary duties. You can see information about business opportunities, and then you can have a straight out non-compete. So let's talk about the three of those. So let's talk again about the person who's building their career on this particular business. They are, again, we'll go back to the same example. You have the investor, the buddy who has the 100K, and then you're the minority owner. You're going to put so many years for equity, and this is your livelihood. What are your fiduciary duties? Fiduciary duties are duties that generally an officer of the company owes to the business, right? So if you see fiduciaries in your agreement, understand there's a meaning under state law on fiduciary duties, and some of those can and cannot be waived. So if you're accepting a job as the CEO or CFO of this business, and you have a fiduciary duty obligation under your LLC agreement, make sure you ask, what does this mean? Okay. And I'm not going to go over the detail because these fiduciary contracts or clauses can be drafted in different ways. The next one is interesting. So business opportunities. So what happens if you are the two partners and this is a furniture sale company, right? You're putting your life on this business. You're running it. You've opened many branches, and your cousin tells you, hey, I want to do furniture business too. Why don't we partner up and do it this other company? So that's a business opportunity in a similar business under your current, basically your first LLC. Your first LLC was a furniture business, or is, and then your cousin says, let's go do this on this side. Do you have a duty, or are you free to go with your cousin while you're still maintaining this job? Can you go do this other job as officer, as employee, but also as owner or manager of your LLC? That's a question. It's an open question. You will have to understand what your LLC agreement says and what the state law, particularly the Business Organizations Code of your state. In our case, we're in Texas, and you have to understand, what does that say, right? And so that's, there are some contracts that will say, if you have a business opportunity, you have to present it first to your other shareholders, your other members. And if not, they might have rights and they might have the power to go to your other business and grab the profit. So be careful with that. And then the last one is the true non-compete, which is you may not do X, Y, and Z. So those three types of LLC agreement clauses can be in your LLC agreement and you are not aware. So you should understand what are your obligations. And I mean, especially, let's go to the example of the person who is dedicating their business to this company, right? So these are very important clauses to take care of, or at least understand, because maybe you became an expert and after 10 years, you want to branch out. And you have the know-how, you know how the business runs, you know how much money you need, and maybe your other partner won't let you get off of it. It will keep you to this non-compete or this business opportunity clause, and they won't let you go and be free. So even if you don't have an employment non-compete, you could still be subject to a non-compete from the LLC side. So be careful. And then how they're sorted out and what's their result, if I don't like it, it really depends on a case-by-case basis. So really the best advice is read your contracts, understand your LLC agreement, and if you see any of these terms, make sure you ask a question.
That was going to be my closing question, like if there was one thing, and I think you just answered it, which is dust off those papers, or if you find out you don't have any, go get some drafted. And
right.
The key clauses that we talked about today are just so important to at least understand. And if you don't, raise your hand. Is there an opportunity for people to renegotiate them? Let's say they read it and they find that they've been subject to some of these pitfalls that you talked about. What are their options or potential options?
Right. So they can absolutely renegotiate an LLC agreement. They would have to do what's called an amended and restate it if they have to restate the whole thing. It depends on what they do. But yes, you can absolutely change specific clauses, or you can change the entire document. You wish, as a lawyer, we see so many unfair situations. You wish people would have a more positive side sometimes, but unfortunately, when money comes into play, sometimes, not everybody, but many people will just you'll get the worst out of people. And like I said, best friends are now worse friends, and relationships break. And this is true. And then both people are hurt from both sides. Right. The one that got screwed because the buddy screwed them, but the one that screwed the other one, they know what they did. They know exactly what they did, and it will be on their conscience for the rest of their life, whether they would like to admit it or not. So I would say, don't be afraid. I know lawyers don't have the best of reputations. I think this is, everywhere in the world, I think for some reason we've built this reputation. But at least I know your case and my case, we really do want to help people. We want to see people succeed, grow their business, help their families, become better every day. So that's really, I wish I didn't see so much injustice. But at least when, with cases like the ones I described today, I get to work and try to get some justice for my clients. But yeah, ask questions. Sometimes you can Google questions and find them, but for some of these issues, even us lawyers who do this for a living, we have to be focused. We have to have this paper next to this paper and compare. We have to have different perspectives and context to be able to give you the best advice. But, do seek that advice. It's worth your time and your pocket.
So how can people get in touch with you if they want to, dust off their contracts and talk to you directly about their options, or if there's an international client coming over that wants the opportunity to work with your firm?
Sure. Thank you. So I think there's two main ways. You can go to www.gnslawplc.com. We have a form where you can contact us, and that will come straight to our firm. And then the other way, you can just email info@gnslawplc.com, and we'll get connected with you. We'll send you our calendar to have a quick introduction. Yeah.
Awesome. Well, I can't thank you enough for coming on. It was so good to talk to you. Reach out to Gabriela if you find yourself in need of tightening up some of those agreements. But until next time, thanks, everybody.
Thank you for having me.
Yeah.